On Monday, the Supreme Court ruled that plaintiffs could proceed with their antitrust case against Apple, in which app users are claiming Apple used its monopoly position in apps to extricate higher prices from them by charging a 30% fee to all app creators. We welcome now Jennifer Reed, Bloomberg Intelligence Senior Analyst for Antitrust Litigation, and James Keyte, Director for Global Development at the Brattle Group. So welcome back, James. Good to have you. Jennifer, always good to have you here. So I want to actually quote from Justice Kavanaugh's opinion here and what he had to say. He said, in part, ever since Congress overwhelmingly passed and President Benjamin Harrison signed the Sherman Act in 1890, protecting consumers from monopoly prices has been the central concern of the antitrust laws. The consumers here purchased apps directly from Apple, and they allege that Apple used its monopoly power over the retail apps market to charge higher than competitive prices. That sounds pretty straightforward.
It sure does.
Just straight up 1890 Sherman Act.
That's right.
So what's the issue?
Exactly right. You know, the issue is, how does this case fit into the framework of an old Supreme Court case from the 1970s called Illinois Brick versus the state of Illinois? And in that case, what the Supreme Court decided was that an indirect purchaser of an item from an entity that allegedly monopolized and inflated those prices cannot sue under the federal antitrust laws for damages. Only the direct purchaser, so whatever the person or entity was that was directly harmed by this inflated price. And so in that case, you'd think immediately, well, this would be the app developers that sell through the App Store and have to pay Apple a 30% commission every time an app is sold through that store. These are the consumers that are actually buying and paying those apps that are selling. So the first court said, well, they're indirect purchasers under Illinois Brick. And in this case, the Ninth Circuit said, no, they're not. They are directly buying from Apple. They're the direct purchasers, and Justice Kavanaugh and the majority of the Supreme Court agreed.
So, James, it's important to realize this is not saying Apple's liable. This is just saying you can go ahead with the suit. Before, there was a question whether they go ahead with it at all. They got a long way to go before this judgment. But a lot of the reaction was actually what the lineup was. Because we had Justice Kavanaugh, as I said, joining with the perceived liberals on the court, which was something of a surprise.
It was a surprise, and in some sense, you would think the conservatives would line up on this issue with respect to antitrust, because typically the court is conservative on opening the antitrust laws, to new actions. And so yes, it does just relate to standing. It doesn't relate to the merits at all. It's who can bring the suit. And so what this does, though, is this is going to lead to many more suits. Whether they're meritorious is another issue, but it is interesting that Gorsuch and Kavanaugh are, again, on different sides. And so in that sense, it is a shift in antitrust to open up more lawsuits.
Well, and at a critical time, potentially, Jen, because there's a lot of talk in the political circles about the antitrust laws and whether, in fact, they should be opened up, as it were, changed. We've talked before about what's going on in Europe. And does this indicate maybe the judiciary might be open to some different interpretations?
I think it does signal a little bit of an opening up, maybe not thinking as rigidly as they have in the past about the antitrust laws and how they apply. It may, as James said, this is about who can sue and not about the merits of the case. And so it remains to be seen what will happen here with the merits. But there's so much public sentiment and so much happening in politics about the antitrust laws not properly adapting to or not properly dealing with the power of big tech platforms. And maybe some of that is seeping in, and justices and decision makers are beginning to think about it a little differently.
So they're very different cases. But, James, if you're representing today Google or Facebook, are you doing a careful antitrust audit to say, do we have any places where those plaintiffs' lawyers could come after us?
Sure. I am looking to see where I have privity, where I directly contract with a group, a customer or otherwise, even if the harm is indirect, kind of economically. But I think more importantly, I'm still taking comfort that big is not bad in the U.S. antitrust laws. And monopoly pricing actually is not outlawed in the U.S. antitrust laws. So in this case, where it's a 30% higher fee, whether indirect or direct, it still is about pricing. You need to have exclusionary behavior. So I think the plaintiffs here, these other platforms, know that when these cases proceed, and there will be more of them, it's going to take a creative lawyer and a creative judge to find exclusionary behavior.
So, Jen, to make a turn here, let's just spend a minute on the Qualcomm-Apple dispute. We thought that was all settled, but that was the private litigation. We also have sort of a tussle going on between the FTC and the Department of Justice. What's that about?
It's such a strange situation. The FTC sued Qualcomm for allegedly monopolistic conduct related to their standard essential patents needed for a standard in technology. And the trial's finished. It was in the Northern District of California. We're all just waiting for a verdict here, a conclusion by the judge. And in a very strange situation, the Department of Justice filed a statement of interest with the judge saying, can you have a separate hearing and have motions filed just on the remedy if you find against Qualcomm? Because we are concerned about an overbroad remedy. We think it could harm innovation. We think it could harm advancement in the U.S. in 5G. And it's just a very strange thing because it's the Federal Trade Commission that sued.
Yeah.
And you have the dual antitrust enforcer now saying, go easy on the plaintiff.
But it's hard enough for a private company to know whether it's FTC jurisdiction or Department of Justice jurisdiction. Now they've got to figure out the different positions of the two agencies?
Well, yes. I mean, the Department of Justice historically has basically said antitrust law should stay out of intellectual property licensing. These are sophisticated parties. They work it out. Apple and Qualcomm, in fact, entered into a settlement, a 6-year licensing arrangement with a $4.5 billion deal, and that courts should stay out of valuing these licensing arrangements. The FTC, on the other hand, is in it with the suit against Qualcomm. And so they want, especially in the context of 5G and who's going to be the industry or the world leader in 5G, the Department of Justice wants innovation and doesn't want to deter that, with kind of an interventionist approach.